Okay, so we can go ahead and get started. Let's get started. And thank you for the folks that have joined us live today as we work our way through this. If for any reason, you can't hear us or missed anything, we're a small group today. So speak up, chime up, take yourselves off mute and just let us know. Appreciate you keeping yourselves on mute while we work through this. But if you have any questions or anything like that, or want to discuss anything at all, just unmute yourselves and fire away. Doesn't matter. And as we're talking through this or whatever, or you can just put a question in the chat section and we'll get to it right away. So there's no reason to wait till the end, just fire away with questions. And you know what, Larry, Coben, and I, Jaime Jackson, have, to try to do, and what we really want to do is just kind of work through and have a discussion about products liability in Pennsylvania. And, we've called this free webinar series, Products Liability in Pennsylvania, All You Need to Know. And we're fortunate that we have with us in Mr. Coben, probably there is no one who knows more about products liability Pennsylvania law in Pennsylvania than Larry Coben. In fact, he wrote the book on it, right?
That was a long time ago.
It was a long time ago. 1998 is when it was published. And, if you can still find it, I still refer to it constantly, the Pennsylvania Products Liability Guide. And it's as relevant today as it was back then. Now, some things have changed, some things have not, and it's just a good guide. And we'll talk about some of those changes today. So Larry and I will work through this as we go through together. This is intended to be a series, informational series, as we go through probably about, a total of 7 or 8 different topics and presentations throughout this series. Next time, we're going to cover jurisdiction and venue, defenses in products liability cases. Later on, we'll be talking about how to identify products liability cases, how to investigate them, what to look for. We'll be talking about auto products cases, which is a unique subset of products liability, crashworthiness cases, the latest wave of auto products litigation, crash avoidance technologies, and those type of things, consumer products, all things products. We'll be talking about causation, medical causation in products cases, and really anything you guys want to talk about products. So if there's a topic that you want to hear at some point, just ask us and we'll talk about it. So today we're going to start with the building blocks, the fundamentals, right? The legal landscape in products liability and what is the law. And really, the good thing about products liability in Pennsylvania is we own the law. The law is really very, very good for us. And if you really look at the language and the cases and the policy considerations, product liability law in Pennsylvania is great. Right, Larry?
It's very favorable to consumers. No question about it. It is oriented to assist the victims in recovering against both manufacturers and sellers. And, even the changes that we're going to be talking about, Jamie, are still very pro-consumer, pro-victim, but in a balanced approach to allow the defendants to offer evidence which is consistent with the consumer-oriented law that we have.
And as it should be, and Larry's going to control the slides. So if we go to the slides to the policy considerations, and I think we start with this because it's really kind of important. And I think you start with this perhaps maybe in some of your educating the court in either your trial brief or motions in limine as to some of the policy rationale and policy considerations. And that's where a lot of opinions start from as to the reason we have strict products liability. And the basic concept is look, companies, if you're going to sell products to people to use and profit from it, you need to stand behind the products and sell safe products. And when people are hurt by unsafe, defective products, then you bear the responsibility. And that concept and policy considerations, as it should be, is very helpful for injured consumers. And a lot of times, when you're debating issues on admissibility of various evidence, sometimes it's helpful to step back and say, well, wait a minute, Judge. Let's look at, the policy considerations behind strict liability. And does this, what they're saying, does that fit in with what the policy considerations here are? That if you're going to sell stuff, you got to make it safe. And, when in strict liability, we're going to talk about negligence and why you may want to bring those claims and then later drop them sometimes. But when we're talking about strict liability, it doesn't matter what the manufacturer did in terms of, oh, we were super careful, or, oh, we did all the right things. You made a defective product and it hurt somebody is our argument and whatnot. So I think, the rationale behind strict products liability is always very helpful for us.
I think, Jamie, certainly for new lawyers who probably are not versed in the origins of strict liability, it's important, and it's always important. You make a good point of reminding the court when it comes to evidentiary issues or pleading issues, the predicate for strict liability, which really goes back to warranty and the warranty law in the common law, which is, again, as you said, when somebody makes a product and markets a product, you have to assume it's safe. And so what Pennsylvania has done is it basically took that concept and turned it in from a contract, turning it into a tort. And so with it comes the presumption of safety, the presumption that a product will not cause harm or fail in a way to injure someone or cause damage. And so, as you talk about, as we evolve through this and look at both pleadings and evidentiary issue, the concept that this is a promise you've made and we're going to hold you to it is really what strict liability is all about.
And those are also, kind of compelling themes to keep in mind in presenting the case to the jury, because that's what the jury wants. They want products safe to use, and that's the promise they make. As you said, that's a good way to frame the issue for the jury. So let's look at some of the potential defendants. We have the obvious ones: the designer, manufacturer of the product, and in Pennsylvania, the seller, distributor, supplier, anybody in the chain of distribution can also be held strictly liable. The lessor, Penske rental truck, anybody who leases a product. And that language is very good for us in Pennsylvania. So a lot of times, sometimes we might overlook a potential defendant if the manufacturer is not solvent or other potential parties.
Well, and the other thing you keep in mind is that there are other reasons to join entities other than the manufacturer. People sometimes think, well, if I have too many defendants, I've got a bunch of lawyers and I've got to deal with all of them, and why bother? But one of the reasons certainly is if you have a Pennsylvania vendor or Pennsylvania leaseor with a manufacturer that's out of state and you want to keep the case in state court, we're allowed to add these defendants who are down the stream of commerce. It doesn't mean they necessarily will be there at the time of trial, but certainly for purposes of both jurisdiction and venue, you're going to want to include the local statewide entity to defeat diversity. There may also be other reasons. There may be communications between the parties that may be pertinent to proving issues that we'll talk about later on, which deal with negligence or knowledge of the event, which could also overlap with strict liability claims as well. So there are a host of reasons to include these other parties. Obviously, if you're dealing with a small product manufacturer, bringing in the retailer or the leaseor may help you if you have a claim of substantial damages as well.
And another important potential defendant, the last one on the list, not to lose sight of, is the importer. So a lot of our products that we use come from China or wherever, and Japan, and a lot of times you either can't get to that defendant really, or you got to go through the Hague Convention with a defendant from Germany or Japan or whatever. But the law, again, is very good for us on the importer. And under NHTSA, the Federal Motor Vehicle Safety Act, the importer of the vehicles stands in the shoes of the manufacturer and is considered the manufacturer. Under the Consumer Product Safety Act, there's language in there that defines the manufacturer as the importer as a manufacturer. And some may look at that as, well, that's just a technicality. But I think in a lot of cases, when you don't have another viable defendant, and a lot of defendants don't realize this, they're like, hey, I'm just the importer. I didn't do a darn thing. And that's the point. They're supposed to do something to screen the products to make sure they're safe. So it's just another potential defendant if you're looking at, a foreign defendant. And you may want to consider bringing the case against the importer and maybe only the importer.
And Jamie, that brings up a really interesting topic that is percolating now through the court systems. And that is, companies like Amazon and eBay and those sort of companies, where they are a facilitator for the sale of products by companies that may be either, really shady or out of the country, and particularly from China, because a lot of us are seeing it's virtually impossible to get jurisdiction over the Chinese companies when they create this wall of activities where they don't ever come to the country. They don't ever come here. They sell it to an exporter in China, who then sells it to an importer here, who then gives it to Amazon for distribution. And while there are some tricky legal issues about whether you treat Amazon as a seller, there is a trend in our court system around the country to do that. And so you can't ignore that, particularly when you're dealing with a product where you either can't identify the manufacturer, but the distributor and seller, you're going to have to name them. They may, in turn, through contracts of indemnification, identify the original manufacturer. But in the first instance, we have to be very serious in our selection of all viable defendants. And if there's a legal challenge, we'll address it.
And certainly the way things are sold now and the way people buy things on the internet, you mentioned Amazon, Facebook Marketplace, all these places that now, distribute and sell a lot of products. And there's case law around the country, I guess, going both ways, and it's important that, we recognize them as a defendant and that we get the favorable trend going our way and develop some very good case law. And if anybody out there is ever facing that issue or has that issue, reach out to us. We have briefing cases. We want to help. We're all rising tide rises all boats. We're just here to share and help. That's what we like to do. We enjoy doing it and want to help everyone. So it's important that we develop that new area of case law because it is developing, and hopefully you can develop it in a positive way. So case law, let's talk a little bit about that because really now, 2014, has it been that long? 7 years since Tinkner? Yep. This, I guess, is the new seminal case on products liability that was at the time allegedly a paradigm shift in products liability law.
I call it Back to the Future.
Stuff. What's that?
Back to the Future.
Yeah. And the defense would have, it changed all this, but and in my view, and maybe Larry has a different view, but he'll share it with us. I don't think that this really changed much. It changed a few things, and some things certainly in our favor. In particular, the consumer expectation test, I think, is pretty good for us. But really, to me, the bottom line is what the court really said is like, okay, let's give guidance on how what's a defect, how can plaintiff prove defect, what exactly does that mean? There's really two ways the plaintiff can prove it. One is the consumer expectation test, and we'll talk a little bit about that specifically language, and the other is the risk benefit test or the risk utility test, and plaintiff can proceed under one, the other, or both. And that's really, there's more to Tinkner than that, but Larry, you want to comment on? We'll talk about Tinkner a lot, but
as we go through Tinkner, we can talk about it some more. There are some pitfalls, or at least some risks, if you pick one rather than the other. when you're first starting out in your pleadings, and where you go through the selection of experts and the development of the facts of the case will ultimately dictate whether you think you can just go with one test or you need to do both to hedge your bets in terms of getting to the jury based on what experts will say. But why don't we first talk about, Jaime, how a product can be defective? What are the different topics?
Right, and they can be defective as designed, right? The design is defective. For example, the machine should have been designed with a guard and it didn't have a guard, right? Or it should have been designed with, a crash avoidance technology and it didn't. The design is defective. Can be designed by manufacturer, and we'll talk about the jury. I mean, again, fundamentals, right? This is the law of products liability. Really just go to the jury instructions for a lot of things. There's really a lot of great nuggets and great gems and really a lot of good guidance in the jury instructions. Can be defective in how it's manufactured. And then warnings. We don't forget about warnings, and whether or not it had adequate warnings or instructions on the products.
And I think as we go through this, Jaime, I think we'll be able to focus in more specifically on some of these issues. It is in terms of, well, what do you mean by a design? Or what do you mean by a warning or instructions? And how does that fit in to a potential cause of action? I think your suggestion of looking at the jury instructions is ideal, because I think in drafting a complaint, I mean, that's one place where you might just start. Get the Pennsylvania suggested jury instructions about how something is designed defectively or manufactured defectively, or the inadequacy of a warning, and make sure in your pleadings you've included those elements that you want to pursue. In terms of what is a product, that's an interesting issue. There's a recent case, and I forget the name of it, that said that concrete was a product. You can have all kinds of products, although at one point, I think somebody argued that electricity was a product, and the Superior Court said no. But, in most instances, what we think of as lay people as products would be considered a product for purposes of either pursuing a strict liability or negligence. But in terms of a prima facie case and how you do that, why don't you talk about that a little bit, Jaime?
Yeah, and on products, because you asked the question, well, what is a product? I mean, I guess when I saw that slide, my initial thought was, well, geez, isn't that obvious? But it's not necessarily. And one of the reasons why is, and there's not a Pennsylvania case on this yet, but there was a Wisconsin case or Minnesota case recently where an app was a product, Snapchat. Snapchat had a feature on it called the speed filter. And what kids were doing is driving in their car at 100 and, to see how fast they could get going, and then post it on Snapchat. And very sad case, there was a crash and 3 kids were killed. And the family sued, the owner or manufacturer, whatever, of Snapchat, and they said that was a product.
A prime example just like that is the various systems and apps that give you directions. And some of them will give you information, for instance, that relates to bridges and tunnels and the heights of those things. And what if you have a truck driver who's moving along and he's got this app and it's telling him to go in a particular direction? And believe me, this is a factual circumstance that we're dealing with right now. And he's going to go under a tunnel, and his app says it's okay to go there. And he crashes into it because he's too high, okay? And causes the roof to collapse in, and he suffers injury. Now, that's an app. It's also a product. And the question is whether it's defectively designed and whether or not there's causation. But yeah, I mean, products can extend pretty far out in terms of how you look at them.
Yeah, in this new technology world, there's all kinds of potentially new stuff developing out there. But so how do we prove our case? What's, again, the fundamentals? What do we have to prove? And we have our bullet points here. And by the way, you don't have to write all this down. They're in the jury instructions. We can make this PowerPoint available to you guys and get all this stuff. But the first one is pretty fundamental, and you would want to get this confirmed right away after your pleadings. Is, did they make it? Did they design it? Did they manufacture it? Did they lease it? Did they sell it? And that, by the time of trial, certainly should not be in dispute, hopefully. Really, the two here are, did the product have a defective condition? Manufacturing defect, design defect, and then we'll talk about risk utility and consumer expectation. And then, was the product's defective condition a cause of the harm suffered by the plaintiff's decedent? Those are really the two fundamental ones, but an important one is, did the product's defective condition exist at the time the product left the defendant's control? And not to forget about that one, because and that ties into really the product was altered defense or modified, and we'll talk a lot about defenses a little bit later on. But let's talk about this concept of design defect now, and with tincture and how we prove our design defect. And there's really two tools that we can use. And we talk about the consumer expectation test and the risk utility test. And the consumer expectation test, there's the language, but it's really, in my view, nothing more than, well, what do consumers expect? What do they expect out of a product and its use? Do they expect their seat back to collapse in a rear impact? No. What do they expect out of products?
See, but that begs the question, doesn't it? That's why consumer expectation tests sometimes can be a little challenging in design cases. But there's some good law. And as you've laid out here in this slide, here are the factors. Let's talk about these factors and see how, because the tricky thing is a lot of times a manufacturer will say, wait a minute, this is a very complicated design process, and you can't rely upon the consumer expectation test. It's too simple. Okay, so let's talk a little bit about the factors that apply here, Jamie.
Yeah, and that's what always scares me, actually, is when you talk about, because that's what the defense says, right? Oh, geez, we can't give the consumer expectation instruction in this case because this airbag system is complicated, this seatbelt system is complicated, whatever it is. Oh, consumers don't understand the design, whatever the product is, no matter how simple it is. And if the judge buys that, and if you haven't brought both, and developed and pled both risk utility and consumer expectation, and he grants that motion, then because you're gonna run into that, because the defense doesn't like the consumer expectation test. But it's and depending on what the product is, and I'll use automobiles as an example, and this is sort of what I would argue to the judge when the defense says, oh, these airbag systems are really complicated. The jury just doesn't understand this. I'm like, well, wait a minute. They drive around in cars, right? The nature of the product, people use them all the time. They're familiar with it. They have an owner's manual that tells them what an airbag is, and they have an expectation that if they're in a frontal impact crash, that their airbags are going to protect them. And that's what your advertising says. Their advertising in this type of case is a gold mine.
That's critical because the express or implied representations are critical to defining the consumer's expectation. So getting advertisements, getting showroom, brochures, getting owner's manuals describing things is critical to both your expert and the jury and the judge understanding what are the expectations. And it will allow you to go into some interesting discovery rooms with the defense as they talk about their advertisements and what how the product is supposed to perform. Yeah.
So Larry, let's talk about, you mentioned experts. Let's talk about experts and consumer expectation test and how to use experts on this way of proving design defect, because we're gonna see from the defense, right? Oh, well, Plaintiff's expert is not allowed to talk about consumer expectation tests because that's not subject of expert testimony to testify what an ordinary consumer would expect out of the product. So your expert, Mr. Coben, is not allowed to testify about that. It's what the defense is going to argue.
Well, you begin with the basics on rules of evidence, and that is that experts can testify to ultimate issues when it's going to be helpful to a juror. However, I think the better way to approach it is your expert is going to be talking about, and in consumer expectation tests, you still need experts, okay? I mean, you're still allowed to offer expert testimony as to the design of the product, the functionality of the product, how it's intended to perform, and how it performed here, which was not as intended. And I think those things are certainly part of the factors that we've listed here. And I think that it's a way of explaining to the jury and to the judge, look, the expert is providing the information the jury needs in order to confirm or deny or dispute whether these are expectations that are reasonable.
But I would, guys, when you're drafting your complaint and stuff, look at the language in the jury instructions, especially the consumer expectation test, and put a paragraph in there that tracks that language to make sure you plead that in your complaint. And same with the risk utility test. So both those sort of theories are in there in your complaint. And there's not a lot of case law kind of yet in Pennsylvania on consumer expectation test, but like a lot of Pennsylvania products liability law follows a little bit the trends in California. And there's a couple pretty good cases in California on consumer expectation tests along the lines of the argument that, oh, well, you can't use consumer expectation test because this product is so complicated it doesn't apply. I think it was Romine, R-O-M-I-N-E versus Johnson Controls. It has pretty good language in it. It's a California case, but Pennsylvania courts put some stock in that since a lot of our law kind of tracks and follows the history of California law.
Yeah. Why don't we switch over to the other test, risk utility?
Risk utility test. Okay. And this is important to keep in mind in terms of, and not to forget about the factors that go into this right at the start of the case, not only when you're drafting your complaint, because it really directs what we want to find out, where we go in discovery and the things that we want to ask about. What hazard analysis did you do? What risk benefit analysis did you do? And those types of things. So if we look at, although none of the next slide, the factors considered, none of these are absolute, like, okay, they're just guidance again, but these are the different factors that the court would look to under the risk utility test, or sometimes it's referred to as the risk benefits test, right? Do the benefits of the product outweigh the risk, and that type of analysis, which is a little trickier, and I think a little tougher for plaintiffs to potentially prevail on, and the defendants just have more room for smoke and mirrors and this and that type thing, I guess, under the risk utility test and things that you would want to look at. But there is some debate, I would suggest, is that whether or not you really under Tinkner you need to prove a feasible alternative design. I think some would debate you don't, some would debate you do. I think if you're going to proceed under this theory and this test, you do. It's one of the factors. And plus, I think the jury's going to want to see that anyway. Okay, show me a better mousetrap. Show me a better way. Like here, here's how they could have done it, right? And it's easy. And here's what they could have done.
Well, keep in mind, Jamie, there's as you mentioned, there's a big distinction between what the elements of the defect theory are legally and what you need to give a jury in order to rule in your favor. And frankly, when you're doing design defect, it seems inevitably you're going to have to offer some different design, whether it's consumer expectation or whether it's going to be under the risk benefit test. there's going to be some need for it, even if it's not. And I think most case law in Pennsylvania is you're not obliged to offer a different design, just one that is feasible. You don't have to actually build it and test it. But again, depending upon how complicated the issue is, you may need to do it in order to convince a jury. What really is tricky is how the defense try to use our application of the risk utility test to get in certain defense arguments. Okay. When it talks about the availability of a different product, the defendant will want to say, look, judge, here are all the products that use the same design. I mean, if they're allowed to put in the availability of a different product, we should be able to put in the fact that most manufacturers make it the same way and design it the same way. Or does this raise in factor number 5, comparative fault? Does this deal with the consumer's use of the product? So, and there's case law on that in different venues, in different jurisdictions that we in Pennsylvania haven't yet had to address in our appellate courts. So we got to be careful. We've got to be ready for this stuff.
Or, does this open the door? The defendants would argue, well, now we can talk about safety standards. Well, we met the federal motor vehicle safety standards. It's a factor under the risk utility test. Well, we met this standard or that standard, Nancy, or whatever, which is a powerful defense when the juries hear that, because they're like, well, how can it be defective if it met the standard? Then there's a problem with the standard and it's the government's fault. I think the law, I don't think that Tinkner changed the law on that a bit. The law in Pennsylvania from, Gaudio versus Ford Motor Company, Harsh versus General Motors and others is still good law in Pennsylvania. And evidence of compliance with safety standards should not come in, but the defense is pushing hard on that. And, there may be some judges who, under the guise of this risk utility test, that may, the defense may argue that opens the door for that type of evidence, don't you think?
Well, also, I mean, you can go back to consumer expectation. Judge, as a manufacturer, the consumer expects us to meet standards. So we ought to be able to tell the jury that we've met these standards. Okay, that's part of the consumer expectation, that we're going to do these good things. So, yes, it hasn't changed yet. Yes, there have been some Superior Court decisions in the last couple of years, like Martinez versus Honda and a few others, where they've said, no, we still adhere that there will not be a defense based on state of the industry or state of the art or compliance with federal standards. But, the defense will continue to pound on that. And you're right. We've got to be prepared for it. And, you also need to think about the fact that if your expert puts in a report, if she writes, this product met this, is unreasonably dangerous or defective, despite the fact that it met the UL or the SAE or the NHTSA standard or the Consumer Product Safety Standard for these reasons. Well, Judge, now the plaintiff's expert has opened up the door. So now we're going to bring in that stuff. So, even in writing reports, you need to be sensitive to this and whether or not you're opening a door that you want to keep closed.
Yeah, and in your expert reports, I mean, you think about these factors and discuss them with your experts and what, you want to make sure they potentially cover in their report in terms of these factors. If you're going to have the risk utility test, it's important not to just ignore it and think about it at trial, like, oh yeah, jury instruction. And then you go back and look at your expert report and it's like, oh, he didn't really talk about any of these factors.
He's got to cover it or he can't testify, or she can't testify. So you got to know what the rules are, the law is, and your expert's got to cover it. Let's talk about a manufacturing defect, Jamie.
Yeah, so manufacturing defect. What's a manufacturing defect? A manufacturing defect would be essentially, and the jury instruction is quite good on this, but it's like basically, okay, here's how it's supposed to be built. Here's the specifications for it, or here's how it's supposed to be built. But oops, this product, it's supposed to be built with 4 bolts and it had 3. Okay, that's a manufacturing defect. That's the concept in terms of a manufacturing defect, or it's supposed to be built this way, and they missed 3 welds, or they didn't put the clamp on, or things like that.
Okay, I mean, we can get to that. We'll come back to that in a minute. Let's also talk about in strict liability what is meant by warnings.
Yeah. So what is meant by warnings, Larry? You want to talk about that?
Well, we'll get into it also in negligence. The problem is that strict liability, as it relates to warnings and instructions, is really not much different than it is under Pennsylvania law with negligence. And frankly, I think that the better approach is, and you have a couple of different ways. Either you have no warning of a particular danger, or you have an inadequate warning of a particular danger, or in your instructions on the use of the product, you left something out that's critical and was causative of the injury. Okay. And if you have any of those facts, then it can probably fit in either as strict liability, where you may be able to avoid the defense of comparative fault. Remember, that's the really important part of proceeding with strict liability. There is no comparative fault. Or you could go with negligence, but then you're stuck with some comparative fault. Now, we'll get back into that again. In terms of that, like you said, the manufacturing defect, obviously, one way to prove that would be if the product just malfunctioned, right?
Right, malfunction. So it's like you don't need to prove a specific design defect necessarily, but it is what happened, right? Something happened, and you might not be able to exactly pinpoint what went wrong or what broke, or it's just that, well, that shouldn't have happened. Like when you think of something the way it normally works, and whether it's fireworks or whatever, something, well, that shouldn't have happened. It doesn't usually work that way. What happened? The key here is that you really got to eliminate other possible causes. It's kind of, if you think back to law school, the res ipsa case, it's like, well, we've eliminated all this other stuff that, it was nothing else, they maintained it properly. They serviced it properly. Nobody modified the product. There's really no other explanation for this other than something with the product went wrong.
And now let's go back. Let's step back for a second in terms of strict liability under Pennsylvania law. Tincture did change a little bit of the law in Pennsylvania, at least the verbiage. And one of the issues that comes up all the time now is, okay, if the product is defective, does that mean it has to be unreasonably dangerous? Because tincture said, go back to 402A. Restatement of Tort Second 402A. And the question is, and my position has always been, unreasonably dangerous doesn't mean anything, and there's no reason to tell the jury. Because if it's effective, that means it's dangerous. Why would it have to be, quote, and what does unreasonably dangerous mean? And what tincture basically has said is, look, defect is either it's not up, it doesn't live up to the expectations of the consumer, and that doesn't have anything to do with unreasonably dangerous, or the risks are greater than the benefits. And again, that has nothing to do with unreasonably dangerous. So it's almost like you don't want to give the defendant the opportunity to stand up in front of a jury and say, even if Mr. Jackson's experts proved that the product, could have been built differently, they never proved it was unreasonably dangerous. Some things are dangerous. What are you going to do? So it's a term without a lot of meaning. Tincture really did not address it per se. And we still have history in Pennsylvania law where the unreasonably dangerous concept was rejected years ago. And as far as I know, it hasn't come back in the 156 pages of tincture, although there's reference to unreasonably dangerous. In the bottom line conclusion of the court, it was not per se adopted as part of our law of defect. So you want to try to keep it out because it creates all kinds of issues.
Oh, and I hate that language, right? It sounds like an almost insurmountable burden.
Oh, sure.
It's like, in a criminal case, it's just like that just is terrible language for us, and we don't need to prove it. And it's just, that's a good phrase for the defense, and that's why they like it, and why they want to use it. But you definitely gonna want a motion in limine to keep that phrase out of the courtroom.
Yeah, you want to try anyway. And just for those who are not that savvy, there are jury instructions. There are competing jury instructions around. The ones from the committee that are submitted and used primarily by the court system do not include unreasonably dangerous. The defense bar in Pennsylvania submitted some contrary and different jury instructions, but to my knowledge, they've not been adopted, and courts have not used them, but they're around. And you need to be savvy to the fact that the defense will push for unreasonably dangerous. Now, it is difficult to show differences in some ways between pursuing a products case under strict liability or under negligence. And frankly, I sometimes wonder whether or not negligence really has a place in products liability under Pennsylvania law. Tincture was a little bit confusing, and there's this language in the opinion, which is why at least the chief judge thought that we should go back to 402A, because he viewed it as really a combination of negligence concepts, breach of warranty concepts, and therefore we're not going to have traditional negligence, but we're going to have something less than what we had before, which was viewed by some under the Azzarella case as, quote, absolute liability, which we all know it wasn't. But in terms of negligence in a products case, we have the same concepts that can be applied, whether it's design, whether it's manufacturing, whether it's warning, that, there's a duty. There's a duty to design, to build, and to market through warnings and instructions, something with reasonable care. But the reasonable care in the negligence concept or in the negligence terms for products liability views the manufacturer as an expert of the product. That's classic law. And that's kind of an interesting phraseology. We're not just talking about the regular, they're held to a higher standard. I mean, that's the argument we can make when we get this kind of a charge with negligence for a product design, that they are to a higher standard because of their expertise in this field, and they really screwed up, okay? And what is interesting is that you can apply that negligence not just to how you build the product, but for instance, in the Schimmel case, the issue was whether or not the lessor of the truck used due care when it purchased a truck without certain safety equipment that was available, okay? In that case, it was that there was the manufacturer offered as an option a collision avoidance system, a radar system that would pick up stationary vehicles, and the purchaser, who was actually then going to lease it to another trucking company, or the dealership, selected products to be on their lot without these safety systems. And the court stated that that can be negligence. If they have knowledge of these safety features and they choose not to add them or tell the purchaser that they're available, even if it costs more, they may breach their duty of care to the consumer. So again, that's a different way. You may also argue, well, you just marketed it as a lessor and it was defective because it didn't have this equipment, but you could also make the claim under negligence, and there may be some reasons to do that, or at least through the discovery process, there may be some reasons why you want to continue to have negligence in the case so that you can go and take certain depositions where you might not really be able to justify those in a strict liability case, but you could in a negligence case. So you may want to, so you include it for that reason. Obviously, if you're going to pursue or think you can pursue punitive damages, then gross negligence, reckless indifference, all those things raise their ugly head, and you need to get discovery on those issues as well in a products case. Now, there are also things called negligent marketing. Now we get into the pharmaceutical drug stuff. And I don't want to get into too many details about this as a product. Although in Pennsylvania, you primarily, if you're going to pursue a drug case, are going to have to do it through negligence rather than product defect. But the concepts that our courts have accepted for negligence in a drug case are also applicable to all products cases if you want to apply them. You know, here we're talking about the negligent marketing. And what that I think is important is it brings in a duty of care that relates to both knowing what the risks are before you distribute the product, and then knowing what the risks are while you're distributing the product. And that may raise some additional issues. Now, our courts have defined this basically as negligent marketing. And you can do this through design if you'd like. And for instance, in this case, in the Coloplast Corporation case in the Western District, they were talking about a sling, which was like a surgical mesh implant that caused harm, okay? And they didn't even have to present evidence of an absolute alternative design, but they could if they wanted to. But it's more negligent marketing than it is product defect, because in the case, they were able to show what the manufacturer knew and knew of the risks. And so negligence was applied there. And again, you can look at this from the standpoint of there's a breach of an obligation, okay? And that obligation goes further than just design. It may go to instructions to the user, or in the case of a drug, it may go to instructions to the physician before she prescribes the drug. So there are a host of ways that it may relate to negligence. Now, one thing that's that moves back and forth between negligence and strict liability is misrepresentations. And here I've mentioned it in the context of 402B, which is strict liability. But frankly, it's really no different in a negligence case, other than whether or not the plaintiff's comparative fault comes in. But the principles that are set forth from the Clanges case are the same. That is, if in product marketing, you make a representation of fact that turns out to be incorrect, whether it's intentional or not, whether it's negligent or not, and it causes harm by taking the product, by using the product, and then that harm precipitates injury, you can pursue it either as a misrepresentation under strict liability or negligence. And now we go back to the interaction between these representations and either consumer expectation or misrepresentation. For instance, here's a prime example of what everybody's seeing these days with cars that are being sold over the last 5 years. All these representations about what collision avoidance systems in vehicles will do, okay? And I just pulled up one from Toyota where it says it's going to tell you when you're heading towards another vehicle and the other vehicle is going not as fast as you or is stopped, okay? Well, the problem is most instances, this is only going to work up to about, the way they're designed now, up to about 35 or 40 miles an hour. If you're going 50, 60 miles an hour and there's a vehicle in front of you even stopped, you are not going to get a warning probably until it's too late to do anything. And the question is this a misrepresentation? Is this an inadequate instruction? Is this simply a defective product? And I would submit to you, you want to put them all in the claim, okay? And that's why warnings, instructions can be either, all right? It can relate because the duty extends to both reasonable care and defect. So it can extend both ways. Now, when you're talking specifically about warnings, do not forget instructions, okay? And do not forget what's being told to the consumer, because what you're going to find in a lot of instances, regardless of the type of product, is the consumer used the product a certain way and that caused the injury. And it may very well be that's either because of the way it's designed or because there is no warning or instruction, or whatever was provided was totally inadequate to properly use the product. So we can cross over into a whole host of these theories. And what I think is really kind of interesting is, well, how does the duty extend beyond what you do when you first release the product? And I think there's some developing law suggesting, certainly in the Lance case, when it came to drugs, that suggested there's a continuing duty. That is, if the product's out there and during its usages, the manufacturer is alerted to risks that were not known beforehand, that there is an extended duty to do something, okay? And the case law kind of splits on what is that something. What should you do? What should the manufacturer be held to do? Is it just another warning? Is it what we would call in the auto industry a recall? What is it, okay? And that continuing duty is questionable in terms of how you might apply it. For instance, in the Magic case years ago, the court found that there was a continuing duty. Once they became cognizant of the need to make a change, okay, because of the way the product was used. In other words, it wasn't dangerous, defective when they marketed it, but they found out through field information that the way the product was intended to be used was causing harm, and that they could change it and make it safer, okay? And that then what that really relates to is what we had both in Walton, because in Walton, the court said that yes, the helicopter manufacturer had notice of the problem. They could identify all the owners, and so they had an obligation to reach out to them. Does that apply to in Walton, of course, it was a very limited market, okay? It may not have been more than 100 helicopters. What about when there's 3 million cars out there or 5 million products out there? Do they have a duty? And how do they meet that duty? You know, and I think the point is that if in fact the manufacturer learns of the problem after it's released and has the ability to identify the users and either provide a warning or a corrective action, that the law is going to extend to that. I mean, the ideal, or not the ideal, but a major case that proves that, even though it wasn't actually ever resolved, is Takata airbags, okay? Once the manufacturer learned of it, they hopped on it and they dealt with it. Of course, they ignored it for a while, even though they had some knowledge. But once they did, they knew they had responsibility. And that responsibility can be followed by either negligence or strict liability, okay? And once it's identified, there's no reason why it should not extend beyond just marketing the product, okay? So then that brings into focus discovery of what they know and what they learned, even after the event, okay? Now, when it comes to warnings, one other thing I want to talk about, which is kind of interesting, and that is a presumption. Our law does indicate that if an inadequate warning was given, and a good warning should have been given, that there's an evidentiary presumption it would be heeded. So again, this helps you in proximate cause. So as you phrase the complaint, as you phrase your discovery, as you phrase how your experts deal with things, they need to talk about, well, yeah, causation-wise, sure, anybody reasonable would have followed this and would have applied this. So that's another issue to keep in mind. Sometimes in these cases, there are failures of a product that relate to an integrated part in the product. And when Jamie was talking early on about who to sue, sometimes you want to, if you can identify that the failure and the harm was caused by some component within a product, okay? You may have to or may want to sue the component part manufacturer because you're going to get additional discovery, additional information. It doesn't let the product manufacturer off the hook, but there may be reasons to include a component manufacturer, although our law on component manufacturer is very limited in terms of when they can be held responsible. So I think this kind of brings us back to who we name, why we name certain parties, and whether we do it as because the manufacturer of the component was aware of the risk when it sold the product, or if it's strictly liable. And so we bring back into focus the fact that you want to do both strict liability and negligence in these product cases.
A lot of brilliant stuff buried in there, and very crafty, clever lawyering that when you peel away the layers of the onion, you really need to think about beyond just some of the basics of design defect and manufacturing defect. And it's also critical for a lot of reasons, especially in discovery and the scope of discovery. But two things that I'm reminded of on misrepresentations, don't forget about that theory and be sure to include it in your complaint. I learned almost the hard way once because I didn't, and it is, I think it's restatement 402B. There's a separate section on it. And it's a separate theory a little bit from design defect. And I didn't use those specific words, misrepresentation, in the complaint. On the eve of trial, they filed a motion in limine arguing that I could, because I'm like, it turned out that it was a pretty damn good case on misrepresentation, because in the way they defended it, they said these molders boots for use in a foundry. And then they said, oh, no, they're not meant for that. I'm like, well, here's your advertisement. And I'm like, okay, misrepresentation. And they're like, well, you didn't plead that, you can't argue it. And I got by it, but barely by the skin of my teeth. And since then, I'm like, okay, it's going in every complaint. So just be sure to plead it, throw it in there, because you might need it later. And then the post-sale duty to warn and whatnot, include that, because it's really helpful in discovery, because they always want to shut you off on the date of the manufacture of the product. Well, this was a 2015, Chevrolet Silverado. We'll give you stuff before then, but you get nothing after 2015. Like, well, wait a minute, there's lots of reasons why we should get it, but one of them is the post-sale duty to warn, right? What they know, when did they know it? Did they make changes? And it just opens the door to that type of discovery. So include that in there as well for those reasons, so we can have the scope of proper discovery. So, guys, thanks for joining us today. This has been fun. It's been great. I learned a lot just going through this stuff again. When you talk about going back to the fundamentals, the building blocks, the jury instructions, the case law, go through and read Tinkner again and again and again, and you'll see something that, oh, I never saw that before. Or, oh, the jury instructions at the start of your case. Oh, I never saw that before. And we're reminded of some of these things. So we're going to keep doing this. We'll do our next one. We're going to talk about, because this is really, when we talk about trends, jurisdiction issues and venue issues, and those fights and things that you want to do to make sure you have jurisdiction, you can keep jurisdiction, do discovery, and all of those type of things. And then we'll spend some time talking about defenses in strict liability cases, negligence cases, and warning cases. What are the typical defenses that we've seen and that's Larry's seen over the years, because he's seen them all, and they still come up with new stuff nowadays. But Larry, before we go, there was a question about Amazon, and we can talk a little bit about Amazon.
Sure.
A little bit more. And John, I think it was your question. So, feel free to unmute yourself and ask or discuss anything that you want to talk about. But, Amazon as a defendant potentially in the retail distribution chain of a product, right?
Yeah, I'm pretty sure I think there's a Third Circuit case. Oh.
It is a Third Circuit case. Yeah, I forget the name of it, but it's a pretty good case for us.
It is. Although there may be some contrary, I know there are some contrary trial court opinions. I don't know if any other court of appeals has addressed it yet. my expectation is at some point they'll try to get it to the Supreme Court. But at the moment, I think the Third Circuit did decide that under it's either Pennsylvania or New Jersey law, but under one of those laws, I'm pretty sure they decided that they should be viewed as a seller, contrary to some federal statute. But again, it is a trending issue.
Yeah, and it's an important one. And if we can keep that trend in the right direction, when we have these, sellers of products, where all these products come from nowadays, and a lot of times there's no recourse for injured plaintiffs. And now, if Amazon's going to put it out there in the marketplace and make money off it, that takes us back to the policy considerations where, look, you're selling this, you're making money, you're in the distribution chain, you're taking a profit. Buy insurance and stand behind the products that you put out there.
Yeah, I don't really see from an analogy standpoint, how is it any different than, now we have car dealerships that are actually selling their vehicles online. You don't ever go into the dealership. Okay. So I'm marketing and you're buying online a car. And I don't ever have to walk into the dealership. They'll deliver the car to me. I mean, it's no different, and it's not the dealership's car. It came from GM, right? So why, and if the dealer can be held liable, why shouldn't Amazon be held liable? Just because they're marketing online? I mean, that doesn't make any sense. Although, again, there is federal statutes that do deal with this issue, and the Third Circuit had to confront it. So you have to be very careful about that stuff.
The Amazon case was the Oberdorf case.
Yeah, thanks, Jack.
Yeah, and I spoke to the attorney who in that case, because I just sued Amazon on not a product liability case, but I wanted to talk to him about how he dealt with Amazon generally. That case was settled on appeal to the Pennsylvania Supreme Court.
Oh, it went there for certification on the issue?
I think so, because they had requested, the Third Circuit on bank had requested that.
Well, I guess that just raises the issue whether or not the Third Circuit opinion is still viable.
Well, the case was dismissed upon agreement of the parties, pending, right? So
did they withdraw the opinion? Because that's the issue. We'll have to take a look at that.
Yeah.
Well, as a 3-judge panel ruled that Amazon could be held liable for defective products. I guess then they asked for an en banc, and then the panel for the en banc asked the Supreme Court, I guess, and that's when it was dismissed. So I don't know if they withdrew the opinion.
Yeah, we'll have to take a look, because if they didn't withdraw the opinion, it's still good law, I think.
It should be good for us.
Yeah, even if they withdrew it, I mean, I would try to either cite it or plagiarize from it and use it in any of my briefs. So yeah, but that's I'm not surprised that it settled when it went over to the Pennsylvania Supreme Court. Because
right. So the quote was, "This is an issue of first impression and substantial public importance, yet we cannot discern if and how Section 402A applies to Amazon. We are, as a result, unable to predict how the Pennsylvania Supreme Court." That was what Chief Judge Brooks in the Third Circuit wrote in his order.
Yeah.
For requesting clarification. I mean, you want the name of the attorney by any chance?
Well, we got the opinion name, so we'll check it out.
Yeah, I spoke to Wilk. And
I think the important thing right now for those of us who are trying to follow that lead is to see whether or not the opinion was withdrawn or not.
Well, I'm sure Amazon settled it because they didn't want the Supreme Court of Pennsylvania to rule. Oh, sure. They weren't very confident about it, I'll bet.
Oh, no question about it. Yeah.
Okay, just thought I'd add that.
Thanks, Jeff. Appreciate it.
Sure.
Very helpful. Thanks. Well, look, folks, that's what we had for today. We covered a lot. We will make the power, we can email for those that are with us today, send you the PowerPoint so you have it. There's a lot of good language in there. We'll make it available on Larry's website at Anapol Weiss and make it available on my website so you have it. And whatnot. We'll do this again in about a month. We'll probably shoot for like mid-July, and we'll do, jurisdiction and venue and defenses, probably July 22nd, right in there. Do it about noontime over lunch. And we'll just keep going through these, and we'll share ideas and learn ideas and share together and develop and continue to develop hopefully a good law and whatnot, opinions for all of us in all of our cases as we paddle along and help each other out, because that's why Larry and I are doing this, to help each other out, share ideas and share things. We enjoy doing it and helping out where we can. So feel free to reach out to us at any time if you have any questions or follow up or a brief or complaint, anything like that. We're just here to share and help you guys out. So thanks for your patience and listening. And Larry, I'll hand it off to you for one final word before we finish.
That's all good. Everyone, enjoy the day, what's left of it. Take care.
Perfect.
So long.
All right. Bye-bye.
Thank you.